Good afternoon. My name's Don Vivrette, and I'm the host of today. So what I thought I would do is there are some slides I want to go through to give you some items to think about or to work with this. And then I'll have Pete and Fred join us. So let's do this. So today is the second week of It's the Estate. My name's Don Vivrette, philanthropic advisor with Finance and Estate Literacy. As I said, I'm the host in terms of going through and keeping track of this. The process you've gone through to get here, you registered for one or both, maybe money and estate or one or the other, whichever it happens to be. What you've also done then is gotten a reminder. Probably you got one yesterday and you got one about an hour ago. I point that out because it tells you at the bottom, you can get the materials and the handouts for today, articles, whatever else happens to be there that you'd like to take a look at. You cannot turn on your audio or video. That's not available to you in a webinar environment. At the bottom of your screen, and you may have to move your mouse or tap the screen or something to see it, there will be a Q&A button. I'm curious. Yes, I just tapped. My laptop's over here and it's logged in. Yes, that gives it to me. So you'll see a Q&A button. You can type in questions. My job through this, once we get through this introduction, is that I will be tracking the questions, asking them. I may be able to answer them without help, but we'll go through and do those and keep track of them. The sessions are recorded. In fact, yesterday's session is already posted. If you watched It's Your Money yesterday, it is there already recorded. We thank you for being here. And let me just walk you through a couple of things. So this is the website that you saw that note. It's on your reminder form. Brings you in here. Once you've done that, click. Now in this case, I left it at week 1. It's now week two. So the presentation material is there and available. And as you can see on this one, the video was available at the time for week 1 when I was doing this. So that's available. The other thing we were asked last week, I think it was, don't know which session, tell me about the sponsors or how can we get more information? 2 things. One is if you go up to the upper right on that, the website, it will say sponsors. And it gives you, here are the sponsors that we have had with us, some in the past, some now. Generally, if you click on it, it'll take you to their website and give you information. Also, later in what I'm doing now, we normally have the nonprofits coming into a 3 to 5 minute presentation. We're doing that virtually, and you'll see that in a couple of minutes when, in fact, the American Heart Association will do their presentation. There is, depending on the computer you're in, between the text of what I'm talking about and my picture, there's a little vertical bar. If you slide that left or right, it enlarges the words and shrinks me, which is probably the best thing you could do to yourself. Also, as I said, if you tap your screen, you'll find a Q&A button at the bottom. Type in your questions. Chat. If you were with us in the spring when we did this in Laguna, we were in meeting, not webinar. So then we used chat. Now we are not. Now we are using the Q&A function to be able to go through and do this. Schedule-wise, we're currently in the estate section. We're doing estate planning basics today. We move on through the various weeks. Hope that you will stay with us and join us as we go through. These are the locations that we typically are at. In this particular case, we're not there because of the virtual world. So we're noting the fact that here's who they are. These are the various participating charities. As I do in every session, shout out to Chapman University for 10 years of being sponsors of the organization and what we're doing. And in fact, David Moore from Chapman will teach the charitable giving module that I'm doing on week 5 with David. So that's what we're doing. The Heart Association is the charity that we're highlighting today. Here's Bonnie's information. She's going to, some of these we did as interviews. So you will see me in a different light because I'm interviewing her. And that's what we're going to go through at this point. So let me bring that up for you. And hopefully that works right. Boom. Bonnie, good afternoon. Why don't you tell us about your organization and what you do?
Good afternoon. I'm Bonnie Harris Hayden. I'm an estate attorney and I do charitable estate planning for the American Heart Association. The American Heart Association is the world's largest volunteer organization working on cardiovascular disease and stroke research. We have over 40 million volunteers and supporters worldwide. The American Heart Association was established in 1924 by 6 cardiologists, and our mission is to be a relentless force for a world of longer, healthier lives. We do this work because heart disease is the #1 killer of people worldwide. Heart disease is the #1 killer of women as well. And stroke is the #2 killer of people worldwide. So every day, 2,300 people die of cardiovascular disease. And every year, 800,000 people die of stroke. So we do this work to help people have longer lives, more time with their families, and better quality of life. And the way that we do this work is through research, advocacy, and providing emergency cardiovascular care. So if you pop up this little slide that we have, you can see the scope of the work that the American Heart Association does. Thanks to our generous donors, we've invested more than $4 billion in research since our inception, and we've funded 13 Nobel Prize winners. Some of the work that we're doing right now, of course, centers around COVID-19 research. And we are researching how COVID-19 affects the heart and affects people with heart disease, and also how it affects blood clotting. We have given $2.5 million in research grants for this research, in addition to, of course, trying to help fast track a vaccine. We all want that to happen. So that's the kind of work that we're doing on COVID-19. With regards to research that doesn't have to do with COVID-19, we are researching the effects that chemotherapy has on the heart. This is called cardio-oncology. And we're also researching the link between cardiovascular disease and diabetes. And so, as you can imagine, we are partnering with other organizations to do this work as well. And when it comes to advocacy, we're doing a lot of lobbying and advocacy work on e-cigarettes and flavored tobacco, and trying to make sure that our kids do not fall into the habits, the unsafe and unhealthy habits with these things. And so we actually just had some legislation in California pass about flavored tobacco just yesterday. When it comes to education, we teach people about how to do CPR. And these days, we're teaching people how to do CPR during the pandemic safely. We also educate women about the symptoms that women experience with regards to cardiovascular disease, because it is the #1 killer of women. And of course, we want to educate the people who love women about these symptoms as well. And that is through our Go Red for Women initiative. So that is some of the work that we do. But as you can see on the wheel, on this, we call it the rainbow wheel, there are so many areas of our community and our health that the American Heart Association touches. And I think that in addition to the advances that we've made in technology when it comes to being able to do certain kinds of surgeries and procedures now laparoscopically instead of being so invasive on the body, and creating drug-eluting stents and new kinds of heart valves. We are also measuring our success in terms of the overall rate of people's blood pressure dropping, in terms of there being a smaller number of smokers in the world. Those things are all wins for us.
What do you do locally?
Yeah, so locally, so we have CPR kiosks in the John Wayne Airport, and not too many people are traveling these days. But when people do use that airport, they can actually learn CPR for free at these kiosks in the John Wayne Airport. It's pretty amazing. And so there's also a lot of other work that we do locally in Orange County the American Heart Association, we're headquartered in Dallas and we work with 93 countries all over the world, but we have offices in Orange County and we do a lot of work for the Go Red for Women movement in Orange County as well. We're very happy to talk to you about any of the local work that we're doing. And you can reach me and the American Heart Association with the information on the slide that is right here. And so there is my email address and our 1-800 number. You can ask for me and they will get you to me, and I can help you when it comes to hooking you up with the right people in the Heart Association that you have questions about our work and various aspects of our mission. And I can also help you if you would like to make a gift to the Heart Association through your estate plans. I would say that just in closing, getting back to that wonderful rainbow wheel, the American Heart Association is really committed to health equity, to making sure that people have access to good quality healthcare no matter what their background is or where they're from. And that also ties into making sure that people have access to healthy food and produce and being able to get to their doctor's appointments and to the market safely. And so the American Heart Association works with local police, we work with farmers markets, grocery stores to make sure that people can have access to food and care as easily as possible. We even work on the homeless situation in several cities and areas around the country. And so the American Heart Association is probably doing things in your community that you didn't even know that we were doing. And so we can help you fulfill any kind of philanthropic goal that you may have. And we're so happy to partner with you. So thank you very much.
Whoop. Let me move these guys out of the way. Pete, would you like to talk about the Heart Association?
Just a couple of things. One is that the Heart Association doesn't get a dime from U.S. taxes. It's completely voluntary. And they just have a resource of information regarding strokes and heart attacks. And it's totally not product driven. And and one of the nicest things, if you have someone who has died from heart disease, it's just it's a great way to memorialize them by giving something to the Heart Association so they can continue in their research and efforts to prevent the heart disease. Online, we have an article called "It's Good to Give," and you're doing yourself a favor when you give. And I know that's hard to realize that you're doing something for yourself when you're giving money away, but you really are, whether it's a money or whether it's a volunteer. Some of the happiest people are people who volunteer and help other individuals. Let's get started on our program today, Estate Planning Basics. Fred, why don't you go ahead and come online
And while Fred's doing that, I'm going to note the fact that I'm going to disappear because I followed the question and answers. There have been a couple of them. I'm sorry that one of you couldn't see the video. It seemed to have blanked on your screen. I can't answer that because I have a laptop sitting over here that acts like you do an attendee, and it was working great. And I know Pete would have yelled at me if he couldn't have seen it. So I'm going to disappear and I will ask questions. Some questions that are asked, I'm going to send you back a note and say we're going to defer it to another time, because we will be covering some of those subjects in depth later on. So I'm going to disappear, but you'll hear from me occasionally. Thank you.
Yeah, one of the questions was regarding an executor, and we're going to have an hour and a half speaking about what it takes to be an executor or a trust administrator. So I'm going to ask you to kind of hold off. One of the things, this is going to be the estate planning basic session. And so lots of new terminology, some concepts. If we use a term that you do not understand, please do a quick message to Dawn and we'll define the term, and we'll try to go slow enough to and not use terms of art and try to make this into a plain English session. Fred, why don't you pull up your outline for the day?
Yeah, absolutely.
And one of the first things that we do for all of our presenters is we go through their Ask First form. The first couple of slides, by the way, this entire presentation is available to you online. So I don't want you to feel that the first couple of pages where Fred talks about himself, you can actually, go and get it and read it. But let's go through the basics. Your master's and other advanced degree, Fred, is where?
I have a Juris Doctorate. I obviously went to law school, graduated from law school, and so that's what a Juris Doctorate is.
And when you say 15 years of relevant experience, what does that mean?
I've been working strictly in the field of probate trusts and estates for over 15 years now.
Okay, and so you don't practice in other areas, family law, corporate law, etc.?
No, I don't. I mean, sometimes there'll be a little spillover, but generally speaking, 99% of my work is all probate trust and estate matters.
And why is that important, let's say, for a consumer when they're looking for somebody to do their estate plan?
Well, you need somebody that knows what they're doing. Just like you can go to a specialist, for a medical need, to a doctor that, specializes in radiology or whatnot, or a different area of medicine. The legal community, in the legal field, there's, niches within the field, within the practice of law. And you really want somebody that knows what they're talking about, that's seen these documents drafted, seen them litigated, seen what happens when an estate plan is done right and when an estate plan is not done right.
So in your practice, do you draft documents?
I do.
Do you handle litigation?
I do.
And do you handle trust and probate administrations?
I do.
Okay. You have a license to practice law. Your license number is there. Is it easy for someone to look you up? And what would they find if they looked you up?
Well, you could look me up on the State Bar website, which is calbar.org. And then there's an attorney search box, and you just type in my name, or if you know my bar number, you can search by bar number. And then it'll say, when I was admitted to practice law, where I went to law school, where I went to undergrad. If I have a legal specialization, it'll be listed there. And on top of that, if any attorney has they got in trouble at all, it'll actually say on the State Bar website. So it's a really good tool to get a little background information on a potential attorney that you're retaining.
Yeah. I would recommend it highly to any attorney that you're going to go to the bar, search, put the person's name in there and see whether or not that individual actually, one, practices in California. The estate planning area brings in a lot of people from out of state. You need somebody who's local, and is licensed in the state of California. And you want somebody who doesn't have a disciplinary history.
It's also, real fast, it's also important that that you make sure that they know what they're doing, because a lot of people they'll say they practice trust in estates when in reality they it's something on the side. They just want to get clients to pay them. So
yeah, well, I usually if I look an attorney up on the internet and their practice, and then I usually click on their practice areas. If they've got 5 to 10 practice areas, I know they're not a specialist in the estate planning area. Another way to determine whether or not you're a specialist, what does this certified specialist mean?
Yeah, a certified specialist is somebody that took an additional bar exam dedicated to a specific area of law. And in addition to doing that, you also have to be recommended by a certain number of peers and judges. What happens is there's a board of legal specialization that reviews the application of individuals to be admitted as certified specialists. And it's a pretty rigorous test. You really need to know what you're talking about. And it's rare that you actually see people, with those credentials.
Yeah, I think there's only about 200 certified specialists in the entire state of California, but it does have meaning. It's not just a give me certification.
Oh, it absolutely has meaning, because it shows that the person that is holding themselves out as knowing what they're talking about. Well, they passed a pretty intense test
Yes.
specific to that single area of law, as compared to like the bar exam is just a general test. There's all different subjects on it. So that's what
you practice law here in the state of California. You got an active practice. You put your client's interest first. How are you compensated?
It varies depending on what I'm doing for clients. Some clients, I perform services on an hourly basis. Some clients.
What is your hourly rate, Fred?
It's typically $4.25 an hour. But again, not every matter is based on an hourly rate. Some stuff
so
is
if I needed to put for you to put an estate plan together for me, I have $1 million estate. I have about 4 different major assets. I'm married. Approximately, what would you charge for to do my estate plan? And remember, I'm your friend.
What we do is it's a flat fee for purposes of drafting of estate plans and meeting with clients and educating them on the process. My office for a married couple, and the scenario that you're giving me, it sounds to me as though a trust is in fact appropriate. The fee would be $29.50. That includes a trust, a will, power of attorney, advance healthcare directive, deeds for the real property, and there's some other documents, but that's the main stuff.
Okay. And if somebody wants to come back in, let's say 3 or 4 months later to review those documents, how do you charge for that?
Usually I'll review on an hourly basis. If a client tells me in a very brief telephone call, they know exactly what they want to do and they want to make some changes, and I know I'm going to be doing an amendment, to the trust, then I can give them a flat fee and it wouldn't be on an hourly basis. So it really depends on specific client circumstances.
Okay. Do you give your time away with a free a telephone call or an email or a free office visit?
All the time. It depends on what we're dealing with. And typically what I do is anybody that, if Pete's given my name out, then I give them a free initial consultation, sit down with them.
So 141 participants today have your phone number, email address, and may be asking you questions.
And a question that has come up from a couple of people, you talk about married and these assets. What if someone's single? Is there a difference in price? Is it less expensive?
It's a little bit less.
Half as much because there's only one?
It's not half as much. There's still a lot of work to be done. Usually what I do for a single person, it's $27.50. Again, there's not much more work that has to be done. It's just an additional will and power of attorney, advance healthcare directive. But when you already have the templates from the other spouse, it's just everything moves so much faster. You're going to have the same amount of meetings with the client, or clients. So that's why there's not much of a difference in price.
Okay. Are you connected with anyone who offers or sells insurance, mutual funds, or annuities?
No, not at all.
So you don't take or give referral fees?
I do not.
Okay. By the way, if somebody had an additional licenses, such as an insurance license and a brokerage license, I know you had one in the past, what would you think? That they're more qualified to do an estate plan?
No, I wouldn't base it on that at all. And actually, that kind of raises some red flags for me. But
yeah. Okay. So you sign under a penalty of perjury that the above is true and correct. And let's get into the presentation.
Terrific. All right. So, Peter, the first page shows a little bit about what my goals are to help people get more information and learn more about trust and estate matters. I don't need to go through it in detail, but
an estate plan consists of what documents? And I think you have it there in the first line.
It's true. So what a typical estate plan, and particularly if you own real property, you're going to have a trust, you're going to have a will, you're going to have an advance healthcare directive, you're going to have a power of attorney. There's some other documents, a HIPAA release, trust certification. There's
But those are the four major documents that you should have when you go into to do an estate plan.
Anytime a client says they want to review their estate plan, I ask for those four documents to be brought with them. And if there was any amendments that they had done since they prepared the initial documents, they need to bring those in as well.
How important is for you to know their family history?
Well, I want to know the family dynamics. I want some background. I want to know, where are risks. You need to know in terms of giving proper advice. Who's going to be the trustee, successor trustee of your trust? Who's going to be the executor named in your will? Who's going to be the agent on the advanced healthcare directive to make medical decisions when you can't make medical decisions?
Yeah. What is their present health situation?
Yeah, and in terms of their trip coming up that I need to be expediting the process.
So you do make house calls and hospital visits once in a while?
Once in a while.
Yeah. Let's go to the next slide.
All right. So before you jump in, Pete, I always say, if you learn one thing from this estate planning basics, webinar, that you learn the 3 T's, and it's title, and title. Everything. Title is so important in the world of trust and estates. It decides how stuff is going to be transferred upon your passing, or who owns the property, who has an interest, who can make a claim on assets. It's just so unbelievably important that you know how assets are titled.
Yeah, I usually recommend to individuals for them to get a yellow sheet of paper and list their major assets, a house, a stock market, mutual fund, etc. And then the next thing right after that is, how do you hold title to those assets?
Yeah, whenever I meet with clients, the initial consultation, we start going through, tell me about your assets. What I always do is I ask clients for the address of their real property. And what I do is I have a title rep that I work with, and I request copies of the deeds for that real property to make sure that the chain of title is correct. I want to make sure that it's in fact in the client's name, as an individual or as a married couple. And because that's for purposes of when you're funding the trust, there's issues there, but title is just so unbelievably important.
Yeah. The 2 other things, and we'll get into those a little bit later, but the, cost basis, what did you pay for the item when you purchased it? And what is the present market value is really important as well. But
there's
title
implications. Yeah.
Title is just, and do most people understand how they hold title?
No, unfortunately they don't. I mean, they'll say we hold it together. A single person, hopefully they know how they hold title, but if they already have a trust, what if they've refinanced their property and they took the property out of the trust to do the refi? And oftentimes the property doesn't get transferred back into the trust, and nobody realizes that. There's a lot going on when you do a refinance. So
what happens? What happens when an individual has title in their own individual name and they die?
Well, it depends on the value of the property. It depends on what type of property it is. But let's say that they pass away and they have a house in their name individually. Well, it's going to require a probate administration. You have to file a petition with the probate court, and it's a lengthy process, particularly here in Orange County at the current state of the court. But there's a lot.
What if about a person who owns title to that property as an individual doesn't have any of the documents, and let's say they have a stroke and they can't manage their own affairs? What happens?
It happens way too often. And what happens is somebody needs to file a petition with the court to be appointed to be responsible for that person and or estate. And that's called a petition for appointment of conservator. And it's an expensive process, and thousands and thousands and thousands of dollars where could have been.
We're going to go through a conservatorship next week, but just want to see what the consequences are when you hold property as an individual. What is tenants in common?
Tenants in common means that each person has an interest in the property, but upon the passing of one of those individuals, it doesn't necessarily automatically go to the surviving tenant in common. It would pass pursuant to that individual's will, most likely.
So let's say, again, nobody has any estate planning documents except that you are a tenant in common owner, and you die or become incapacitated, what happens?
So what happens is, well, if there's tenants in common, obviously you've got more than one person that has an ownership interest in the property. For the person that passed away, if this is real property we're talking about, a petition for probate is going to have to be filed. And in your scenario, you said that they don't have any documents, they don't have a will or a trust. Well, then what happens is there's a law in California called the law of intestacy. And so a person would have to be appointed as the personal representative of the estate, and then it would pass pursuant to the law of intestacy. And I don't know how much you want me to get into that.
Yeah,
right?
we'll go through that in just a little bit. What I find is the next title is the most common. And what I find is most real estate agents recommend joint tenancy with right of survivorship. What does that mean?
What happens under a joint tenancy is, let's take a scenario where two people own some real property as joint tenants. Upon the passing of one of the joint tenants, what's known as by action of law, the interest of the person that passed away automatically transfers to the other joint tenant. So it's a simpler process. Then it avoids a probate. But is that necessarily what you want? Depends on who the other joint tenant is. And on top of that, there's some tax implications where maybe it's not the best scenario.
Yeah, we're going to get into that cost basis and step up in basis in just a little bit. But so joint tenancy, and what happens on the second death of the tenant?
Well, so what happens is, and this happens all the time, where both people have passed away, both joint tenants, and then I pull the deeds and I review the chain of title, and it shows it's still sitting in both their names as joint tenants. Well, then what happens is you have to file a petition for probate of the second to die, for their estate. And then you have to file an affidavit with the recorder's office to transfer, to remove the first to die's interest in the property, so that it all goes into the estate of the second to die. Apologize. And
I'm making sure my phone is off too.
It's quite a process. It requires a probate, requires more work than people expect.
What if I have a scenario where I own some stock as a joint tenant, and it's a joint tenancy, and I also have a trust, and in the trust it says I give this stock to my son, but that stock is in joint tenancy. What wins?
Litigation. Typically, if it's been declared as an asset of the trust and the trust was done after the joint tenancy was established, you could get a court order that severs the joint tenancy. But oftentimes those cases there's usually a fight.
Yeah. Another thing I see a lot of is that parents give their children a joint tenancy interest in their property to avoid the probate. Is that a recommended way to avoid probate?
It's not recommended at all. I mean, what happens is when you add someone on as a joint tenant, there's a presumption that they own a 50% interest in the asset. And so, I've had it in cases where the client comes in and, they have a good relationship with another family member. One case I had, it was a niece, and the niece was on title as a joint tenant. Well, I wasn't the estate planning attorney, but it came to me for the litigation side of it. But the estate planning attorney recommended a trust to the woman. And the woman, she was under her understanding that she paid for the whole house. She owned 100%, but the title didn't say that. Title had the niece on as a joint tenant. And so the estate planning attorney said to the niece, okay, well, here's a deed to remove you as a joint tenant so that we could transfer the property into the aunt's trust. And of course, in that case, the niece said, oh no, I own 50% of that house. I'm not transferring it. And then litigation ensued. So it can cause problems with claims and ownership, and relationships change over time. And I know most people, maintain a good relationship with their children, but holding assets as joint tenants causes issues, and not to even get into the tax side of it.
Yeah. But, I usually recommend if small bank accounts, $10,000 to $20,000, you want to put it in a joint tenancy account,
Yeah, I've got no problem with that. Something small, I have no problem. But if it's a
major
house,
assets, stay away from joint tenancy. How about community property? Community property with right of survivorship.
So community property, California is a community property state. There's some tax benefits to holding a property as community property with right of survivorship. Because what happens is, in terms of the step up in basis issue that you've been mentioning a few times already in this webinar, there's tax ramifications. So it'd be better, and obviously it can only be held between a husband and wife or domestic partners. That's the only way you can hold it as community property with right of survivorship. Like two unmarried, two friends could not hold property as community property with right of survivorship.
And now that you have second marriages, third marriages, etc., does it become kind of confusing because do you have to handle separate property differently than community property? And if there's two kids from opposite spouses, how does that all impact the estate planning process? And
that's something that I have a discussion with my clients about throughout the representation, obviously in connection with estate planning. Yeah, I need to know how an asset is. An asset separate property? Is it an asset that was brought into the marriage? Typically, separate property is what you bring into the marriage, plus any gifts or inheritances that you've received. That's separate property. But then there's a presumption that anything that's acquired during marriage is community property. And in the context of divorce, sadly, it decides how assets get distributed or divided in the course of a divorce. So.
Okay. Let's say for a young married couple or a married couple that doesn't have a lot of assets and they don't want to pay for a trust, would you recommend that they hold their title of their assets in community property with right of survivorship?
Yes, that's exactly what I would recommend.
Okay.
So yeah, it all facts specific, circumstance specific.
Yeah, that's the hard part about doing an estate planning basic class, because you got to know the circumstances of the ownership and the family and marriages and kids. And I mean, you really have to understand it. It's one of the reasons why living trust mills that estate planning attorneys who do, 500 to 600 estate plans per year, they just don't have time to spend with the family members to really dig in to what the circumstance of the family is. And they have a word process documents and one size fits all. And that's the last thing you want to do for an estate plan. We haven't talked about a trust, and we're not going to get into a trust. Yes.
Since we're talking about title to assets, there's a question of how do you handle a co-op property?
I have no clue. Fred, do you know?
Well, co-ops, oftentimes they're held by stock certificate.
Leisure World, Laguna Woods.
If you're going, if that's what you're referencing. In terms of how do you handle it? So, I mean, again, it's specific to the circumstances. Who are the people that own it? What are their goals?
Usually what I've seen people do just in that circumstances they put their co-op stock certificates in the name of the trust. And since we're going to talk about the trust now, what is a trust?
A trust is it's kind of like, it's similar to like a separate entity where you hold title as trustee of the trust. And as trustee of the trust, you have to administer the trust pursuant to the terms of the trust. And
it avoids probate.
And absolutely, it avoids probate. You have more control over what happens to your assets after you pass away. Do you want them to be maintained in trust with a successor trustee administering the trust according to the terms? Or do you want assets just to be distributed outright upon the passing of the trustor? So the trustor is the person that establishes the trust. The trustee is the manager of the trust. And
then the beneficiaries of the trust.
The beneficiary is obviously the one that.
Yeah, we usually think of estate planning as planning for death. Talk a little bit about how important it is to plan for incapacity.
Well, we started mentioning the conservatorship issues that can arise if you don't do any estate planning documents and you subsequently lose capacity. But if you do in fact meet with an estate planning attorney or address putting together an estate plan, you can do an advanced healthcare directive to name who you want to make decisions for you in the event that you lose capacity, that you're unable to make those decisions yourself. For assets that are in your name individually, we have the power of attorney for finance, and that names an agent under the power of attorney to act on your behalf. And the power of attorney can either be a springing power of attorney, meaning it goes into effect on your incapacity, or it could be something that's effective immediately, allowing it, for instance, if you were to go out of the country for an extended period of time and you wanted somebody to be responsible for the assets in your name individually and to pay bills, you can have a power of attorney.
We're going to go through the power of attorney in detail next week, so I don't want to get too far into the woods on that. But what about a single person having a trust?
Well, a trust is nice as compared to just a will. A will becomes effective upon your passing. So a will doesn't have any effect on what's going on during your life, whereas a trust will be an active document during your life.
Do I need both of them? Do I need a will and a trust?
You do, actually. And what happens is when you have a trust, your will is going to be known as a pour over will. And I think we have some slides to that effect.
We're going to cover that in just a little bit.
But in the event that you were to become incapacitated and you have a properly funded trust, then the successor trustee could step into the role as trustee and can assume paying bills from the trust assets. Without the requirement of filing any court proceedings.
Yeah. I usually recommend highly that single individuals do a trust just so that they can name the person that they want to take care of them, bill paying, investments, etc., if they suffer from some sort of incapacity. LLP, LLC, we're not going to get too far into it, but that's another way to hold title.
Yeah, a little more complicated stuff, but yeah, absolutely.
But I want to back up to a question though, in terms of, so if I'm putting my community property into the trust, how is it titled? In the name of the trust, in the name of them? How's it titled?
It would be titled in the name of the trustees of the trust. So generally speaking, a married couple, it would be the husband and wife as trustees of the such and such family trust. And
it's effectively right of survivorship because that spouse is the owner of the trust after someone passes.
So what happens is it still maintains its nature as community property, the asset, for purposes of a divorce. But in terms of administering it upon the passing of the first spouse, well, it would transfer whatever the trust document says. And generally speaking, it says everything goes to the surviving spouse one way or another.
Just so everybody knows that we're going to spend an hour and a half just on living trust. So. But today it's just going to be the estate planning basics. Let's go to the next slide.
Yeah. So here,
what is an estate?
It's a good question. Estate, that's a collection of assets owned by an individual. An estate is not limited to what you have after your passing. It's also during your lifetime you have an estate. It's your financial picture. What are your assets?
And people, what I found too is people underestimate their size of their estate. And that's why I really recommend that putting the asset, how you have title, cost basis, and market value.
And if there's any encumbrance, any mortgages on the properties, what's the current value of the mortgage?
Yeah. You as an attorney would need to know that to do a proper estate plan.
Absolutely. I had a case just last week. I met with some clients, and they have three. The lady has 3 kids, and she wants each kid to receive the same amount in terms of value, but different kids want different properties, and different properties have mortgages with different outstanding balances on them. So, I need to know the full picture to give proper advice.
Yeah, and if you have less assets, you have a less complicated estate. So things are more simple to handle. We're going to get into beneficiary designation in a little bit. Let's go to the next slide.
All right. So now this goes one step further from what's an estate to what's an estate plan. And we've gone into this a little bit already in the different documents that comprise an estate plan. But the term estate plan generally means, what documents, what procedures do you have in place in the event of incapacity, in the event of death? Is everything, or, have you named agents or executors or fiduciaries to be responsible in the event that you're unable to do so, or if you pass away?
Yeah. Let's go to the next slide.
Now here it's why prepare an estate plan? Well, the most quickest, easiest answer is, okay, if you pass away and you actually have assets, you haven't told anyone where you want those assets to go following your passing. So
it goes according to the laws of intestacy. So let's say I haven't done anything, I die, my parents are still alive, and I have 3 sisters. Who does my estate go to?
Okay, so if you've got no spouse and you've got no children, no grandchildren, nobody below you on the family tree, then your assets go up the family tree to the first step, and it would go to your parents.
And then if let's say my parents were deceased, where would my assets go?
Under that same scenario, it would first go to the parents, but obviously, again, they're deceased. But then it would step down to your siblings, so the sisters in that case.
Okay. And that means if you don't have an estate plan, you're going to go through the probate process. And we're going to get through that in just a little bit.
Assuming your assets are at a certain value or higher.
Okay. So preparing an estate plan is who's going to get my stuff. Is that easy for most people?
Not at all. I mean, sometimes it's easy in terms of if, you have 2 kids and, you're a single person. Okay, they're each going to get 50-50, but it oftentimes gets more complicated than that. I mean, what do you do? What if you have no kids? Where's it going to go? Do you want to give to charities? Do you want, what do you want to happen with your assets upon your passing? Or how is it going to be handled in the event of your incapacity?
No, the kids haven't lived with one another for probably 30 or 40 years. And now one of them is going to be named to manage mom's or dad's money.
Well, and I think that having an estate plan that's one of the most important parts of it, because if you haven't named somebody in a document, in a will or in a trust, then the law presumes everybody's equal on the same sibling. Let's say children. You have 2 children. Well, let's say one of them's is really bad at finances and one of them's better at finances. Well, if you were to do a will, you'd probably name the one that's better at finances to be the manager, to be the executor under the will. However, if you don't have a will, you have no estate planning documents, both of those children have the same level of priority for appointment as the personal representative. So obviously in that type of scenario, there's a much higher chance that the individual who's not so good at finances, at them being appointed as the personal representative of the estate, and that can turn into problems.
But Fred, when you say that the children are equals, what if you have a stepsister, stepbrother? How do they fit into children?
So a step sibling, what matters is, okay, so it's the parent, when they pass away, under the laws of intestacy in terms of who has priority for appointment, the stepchild is not on that list. It's just the natural children. An adopted child would be on that list, but not a stepchild.
Okay, let's go to the next slide.
So again, when I started talking about the 3 T's, it's all important because it decides how your assets transfer upon your passing, or again, what happens during your life. So you have not only options with a will or a trust, as I'm sure most people have heard. You could have a multi-party account. That typically is a bank account, a checking account, let's say, where you've named yourself and a child or a friend as a joint tenant on the account, or as a co-owner on the account, even if they don't actually own, even if you don't believe they own an interest in the account.
So having another person on that account does avoid the probate.
What happens is there's a presumption under the law that says that if you have 2 people named on the account and the first person, the actual true owner passes away, that account transfers to the surviving multi-party second person, third person, whatever it is.
How should people hold, this is a common question. How should people hold title to their cars? How does the DMV handle this?
Cars you can just leave in your name individually, unless you're talking about some car that's worth, $100-something thousand. What happens
or
is
if you're a married couple or you own it with another individual, put in or instead of and.
Well, it could have ramifications of upon your passing transferring to the the other person, the or person.
Yes.
Yeah, I mean, different states handle that differently, but California, or my recollection is that would transfer to the surviving
DMV
person.
almost is a whole separate entity from the probate process.
It absolutely is. Although surprisingly, this is the only thing that I think the DMV is a little easier to deal with on.
I go through Auto Club.
Well, the DMV doesn't make you jump through as many hoops as you would expect. Cars are pretty easy, although you want to make sure that whom you want to give the car to, that could be an issue if you have more than one child. What is a beneficiary designation? So what happens is a beneficiary designation, frequently you see that in a retirement account or a retail brokerage account. So upon the passing of an individual, an account holder, the account will transfer to the named beneficiaries that you've designated. It's based on contract law.
And it avoids probate.
It does. So a beneficiary designation trumps a will. So if you have an account, let's say you have an IRA account, and your IRA account, you named, your children as the primary beneficiaries, each to receive 50%, and you have 2 kids. And then let's say your will gives everything to just one of those kids. Well, under the beneficiary designation, that account is going to pass equally to the 2 kids, not pursuant to the will to just one.
We're going to talk about the importance of beneficiary designations when we talk about retirement plans. But just a quick story, at Long Beach State University, we had a professor who was married for 2 weeks. And during that 2-week period, he named his spouse as the beneficiary of his retirement account. He lived with another woman for the next 40 years. And when he died, everybody realized that he had named his spouse of 2 weeks. She received his entire retirement. So beneficiary designations are absolutely important, and you need to make a photocopy of them and bring it into the estate planning attorney so that he or she has the full picture. Payable on death, what is that?
Payable on death, similar to a beneficiary designation. Upon the passing of the account holder, it's paid to to the named POD, the named beneficiary under the POD.
So instead of maybe having a joint tenancy at a bank account, you can go to your bank teller and say, I want a payable on death. And they'll ask you who that person is. And it's a very simple process. And I think the person has to wait 40 days, bring in their driver's license, and whatever is in that particular account, they receive it, no probate whatsoever.
Yeah, you'll have to get a certified death certificate.
Yeah.
Yeah, it's a much easier process.
Yeah. You don't see too much of transfer on death deed. What is that?
Well, they in California, they came out maybe 6, 7 years ago, something like that. It's kind of like a beneficiary designation for real property. And it avoids probate. It's not available for like commercial properties. I think it's limited to properties that have 4 or less dwellings on the property. So if you had a 4-plex, you can use a transfer on death deed. But the law is going to change on it. I think it's in 2025. I think that's when it sunsets. So there could be some potential issues, but it's a possibility.
Transfer. Yeah, it's brand new. It's just be careful. A lot of fraud is committed on transfers of real property. Right of survivorship.
Right of survivorship, just like we were talking earlier, joint tenancy. Upon the passing of one of the joint tenants, the property passes by action of law to the surviving joint tenant. All you have to do, if it's in the context of real property, all you do is you file an affidavit, you record an affidavit with the county recorder's office that says that the other joint tenant passed away. You attach a certified copy of the death certificate, and then that tells the title company or anybody that's reviewing the chain of title that the surviving joint tenant is the sole owner of that property.
So everybody has probatable assets and non-probatable assets. And probatable assets, one of the things that you kind of mentioned this already, if you have probatable assets that are under a particular value, what happens?
Let's say that
I think we got a slide on that. I'm sorry, I'm jumping the gun, Fred.
That's okay. We can go into it.
Okay.
So what happens is, in the event that you pass away, and let's say you don't own any real property, it gets a little bit more complicated when you own real property. But let's say you pass away, and you have a checking account with $120,000 in it. That's a little excessive for a checking account, but you see all sorts of things in this business. So in that case, if that's your sole asset, maybe you had a car that's worth $5,000. As long as the value of all the assets in your name individually, if it's less than $166,250, the beneficiary or the heirs at law, what happens is beneficiary is somebody obviously you name under a will or a trust. Heirs at law is if the laws of intestacy apply and it passes pursuant to the California law. Then those individuals, whoever is supposed to receive the asset, can simply execute an affidavit and you attach a certified copy of the death certificate. You provide that to the financial institution. You provide that to the DMV, and the DMV will transfer the car to the beneficiary or heirs at law.
Yeah. And so we use a small estate affidavit for property that's below $166,000 if it's titled in the individual's name.
Correct. And if it's real property, there's different boundaries of value, but I mean, the chances, if you own real property, there's a higher chance it's going to probate as compared to if it's just cash.
Okay, let's go through the next slide.
Yeah.
What types of wills are there and why are they important?
They're important for multiple reasons. One, a formal will is the typical, if a person goes to an attorney and they, attorney sits down with them, asks them, who do they want to be the executor? Who do they want to be the beneficiaries of the will? There's some more details in there. Should a no contest clause be added? But if an
it's
attorney
typewritten,
it's typed out. It's signed by the testator. Testator is the individual that's whose will it is.
Uh-huh.
And then it's witnessed here in California by two disinterested witnesses.
And do they have to, the two disinterested witnesses, do they have to know the contents of the will?
They don't, no.
They just have to see the testator sign.
Correct. There's some more options to that, but I won't get into it. It's more detail than we need.
Okay. But that's a formal will. Talk about the other two, because those are the wills that usually are most litigated.
Yeah, so a holographic will is a will that's prepared by an individual. The law requires that if it's going to be holographic will, the material provisions of the will have to be in the testator's handwriting. And the law on it's a little strange. I mean, for instance, I had one, I just got admitted to probate, and she didn't actually sign the document, but she, the testator, but she wrote everything out, and she said, whatever, and I'll maintain privacy. Give my assets to such and such. And that was sufficient for the court. But again, if there was a challenge to it, I think that we could have potentially had some problems. But a holographic will, it's a handwritten will. That's
okay. And you don't need it notarized. You don't need a date. No. You just need it in the person's handwriting and to show that this is their intent. Yeah.
And I mean, there's problems that arise if you don't date it in terms of another will, which one was done, if one was done more recently, well, that's the one that should be controlling. But if you don't know what the date it was executed, there could be litigation over which is the appropriate will.
Yeah.
So a lot of times holographic wills turn into litigation.
Yeah. Sometimes I recommend a holographic will to people who are just or have a child, have no assets, and they just want to make sure that they put in writing as to who's going to be the guardian of their child in the event that something happens to the both of them.
Well, and frequently you'll see that, the nomination of the guardian in the will, but sometimes it's just a separate document, and the law doesn't require that be in a will.
Yeah.
So,
How about a statutory? What is a statutory will?
statutory will, what happens is there's a probate code section that provides language of, what a sample will is. And basically companies have taken that sample language, put it on a form, and sold
Fill in
it.
the blank.
They sold it to the stationery store. And then you could go to the stationery store and you pick up a statutory will, and you fill in the blank.
Yeah, it's probably the second most litigated form of a will, because you can't cross out. And it's either you fit in that cookie cutter, fill in the blank, or you don't. And you can't make alterations to it.
And on top of that, oftentimes people will write in something that turns out to be ambiguous or precatory.
What does precatory mean?
It means that this is what I'd like to see happen. These are my wishes, but the law requires a will to be,
specific.
Require you to do this.
Yeah.
It's got to be mandatory.
What is a pour over will, and why do we call it a pour over will?
So again, what happens is when you have a trust, you're also going to have a will. Now, a lot of people say, well, I have a trust. Why do I need a will? Well, what happens is, let's say you pass away and there's still an asset in your name individually. And if there's no reference to that asset in the trust, let's say it's a real, house that you bought years after you did the trust. And when they asked you, how do you want to take title? You said, oh, well, yeah, I want to take title in my name. And so that's how they prepared the deed. And so when the seller signed the deed to transfer it to you, now it's in your name individually. Okay, so you have a trust, but obviously that real property is not in the trust. And then when you pass away, well, how do you get that? Your trust says who you want to receive your assets. That you were clear on. Well, how do you get that real property into the trust? Now you have to file a probate and probate that will, the pour over will, which says everything goes to the trust. And then you get a court order that transfers the real property from your estate, as your individual name, to the trustee of your trust. And so it causes problems. But see, what happens is if you didn't have a will, well, then the laws of intestacy apply. And they would possibly give your assets differently than you set forth under the terms of your trust.
So a will in most cases becomes almost an emergency document.
It's a fail-safe backup net to catch anything that somehow didn't get into the trust.
Okay. Right. Functions of a last will, just go through them.
Yeah, obviously you want to name who your beneficiaries are, who's ultimately to receive your assets upon your passing. Wills, it requires a distribution. Wills, you don't hold assets, in perpetuity in the estate. The assets are supposed to be distributed, through the process upon your passing. It's a tongue twister. And so, you have to name who you want to be your beneficiaries. The manager of your estate, well, that's referencing who do you want to name as your executor. And oftentimes people say, oh, the executor of my trust. Well, the terminology, trustee of the trust, that's the manager of the trust. Executor is the manager of the will of the estate upon your passing. And again, the will governs assets in your name individually. Other things that are in the last will, in the event that somebody was to contest the last will, if they're already a beneficiary under that will, then if they lose in the contest, then they could be removed as beneficiaries under that will. Bond is it's like an insurance policy. In the event that the person gets appointed as personal representative by the probate court, typically the court requires a bond. In the event that that person was to take off with all the money, well, the beneficiaries can go after the bond company and recover, and then the bond company goes after the personal representative. But a will, if you trust the person and you trust them enough to name them as your executor, usually you waive the requirement of bond. Bonds, it's expensive. And then the beneficiaries are the ones that have to bear that burden. Okay. As I said earlier, a will is only effective upon death.
Doesn't do you any good during your lifetime.
Correct. And you can always change a will during your lifetime there.
Let's go to the next slide.
We're jumping.
Okay.
Well, we talked a little bit about the small estate affidavit. I don't think we need to get into much more detail on that.
Yeah, I think if people just need to remember the number. So if you have probatable assets outside of real property, you want to stay below that number. It used to be 150,000. It goes up every year a little bit, cost of living, I guess.
Yeah.
But We had a situation where at Bank of America, we had $151,000 in an account in an individual's name. And we had to go through probate. So it's an important number. Let's go through the next slide. People think the worst about probate, but you're passing on title. You're actually giving somebody your stuff. So the probate process is a judge, right? Who determines.
It's court oversight, correct?
Court oversight. So sometimes that's pretty nice.
Yeah, and you know what? A lot of it, the experience the individual has in the probate process, oftentimes has to, it's a result of the success or failures of their attorney. If you have a good attorney, it could make the process easy.
Yes.
So,
yeah.
and then,
but again, it's the first thing is we got to determine title.
Again, assets that are in your name individually, that don't have a beneficiary designation, don't have a joint tenancy, those.
We just lost you, Fred, or you're frozen on my screen anyway.
Mine
so
too.
I'm gonna.
But let me ask, Pete, you may know the answer to this question. So if I have, is there a limit to how much I can have in my pour over will? So if it would be wrong to do, I know. If I left my house in a pour over will, and that's then going to pour into my trust, does that throw me into probate?
Yes.
So you want to keep certainly whatever's in that pour over under the 166,000.
Exactly. That's why you want to make sure that you understand what your probate estate value is. So,
hi, Fred.
You're back. Good. Go ahead and pull up your.
And you lost the screen share, Fred.
Yeah, and also you're muted.
There we go.
Okay, and pull up your outline again.
Technical difficulties.
This is all new.
What if there's a disagreement between the will and the trust? So the trust says, give it all to Betty. And well, in that case, it wouldn't go into the estate. But if there's a disagreement on distribution between the two, is that simply the court will decide?
It depends on which assets are titled in the trust and which assets are titled in your name individually. The assets.
Title. It is so important. I see so many people go into the expense of a living trust, spend many more dollars than Fred indicated, and then do not transfer the properties into the trust name. And that means
it's worse to have, if you have a trust and it's not properly funded, chances are you were better off not even having a trust.
Yeah. Yeah, we'll go through living trust, but it's just so important. By the way, this probate process is very similar to trust administration. So we need to determine title to assets. The trustee instead of a personal representative. What the good news is about trust, we don't have to petition the court for probate, hopefully.
Especially here in currently in Orange County with the courts being as backed up as they are.
It takes it's almost going to be 2 years today before you can be heard.
Well, no, it's not that bad, but it's pretty. I'm filing stuff now. It's getting set for hearing in like July.
Okay, well, that's not too bad. Publication of notice that the petition is filed. By the way, is the petition for probate free? Does there a cost to that?
For filing of the petition?
Yeah.
There is a filing fee. Yeah, it's about $465, and then electronic
publication of notice that the petition is filed. The ads in the newspaper. How much does that run?
Easy $500.
Okay, then you got to give notice by mail to all the individuals, right?
You got to give anybody that's identified in the will, as well as any heirs at law. All of those individuals are entitled to notice. And
by the way, that's the same process you have to go through with a trust. So there's no difference there whatsoever. Inventory and appraisal. What is a probate referee?
Probate referee is an individual that's appointed by the court to appraise non-cash assets. So let's say you have a house. Well, the court wants to know they have a reliable appraisal. So there's a certain amount of individuals on a list with the court that are, certified probate referees that again get appointed. And so what I do is I I'll list out the non-cash assets on what's called an inventory and appraisal. And it's a snapshot of the value of the assets on date of passing.
And what do they charge?
For purposes, well, it's 1/10 of the value of the asset appraised.
Yeah.
So if it's
And
$1
an
million
inventory-
house, they charge you $1,000.
Yes. And an inventory and appraisal is also needed normally in a trust administration.
You need, well, it's not on the same form, but what you do is you do need a snapshot of what the value of all the assets were on date of passing. It's a requirement under the law, unless the beneficiaries, waive that requirement under the law.
Creditors. How are creditors treated?
Creditors, in the context of a probate, what you do is you give notice to the creditors. And then once you give notice of the probate administration to the creditors have a time period, a window in which to file a creditor's claim, with the personal representative. And then the personal representative gets to look at the claim and decide, is this a legitimate claim, or is this somebody, just trying to take advantage? And then the personal representative has the ability to allow or deny that creditor's claim. If you deny it, then the burden shifts back on the creditor to file a lawsuit against the estate. It's a process, but nevertheless, it eventually works itself out.
Yeah. Creditors are just a major part of the probate process, and also from trust administration. It's a great time to negotiate with creditors as to what you actually pay them, because they don't want to go through the court petition.
You could save quite a bit of money. And credit card bills, or it depends on what the circumstances are. But
but again, same process, whether it's probate or trust administration, it just doesn't happen through the court. Taxes, the government wants to make sure that the person's taxes are paid.
Correct. The personal representative is responsible for ensuring the taxes are current, for the decedent during their lifetime, as well as any income taxes that were required to be filed following the passing of the testator. So yeah, you have to meet with a CPA. I generally recommend clients meet with a CPA or an enrolled agent, and we make sure all our I's are dotted, T's are crossed, tax issues have been dealt with. You don't want to distribute the assets and then later on find out, oh, the IRS is owed a bunch of money.
Who's going to be held responsible?
Most beneficiaries turned around and they probably spent that money. That money's gone.
They're going to look to the executor or the personal representative.
Precisely.
Petition for a discharge.
So the final account / petition for distribution is your request to the court to distribute the assets pursuant to the will. So you have to get a formal court order from the judge stating, yes, the court's reviewed everything. We agree with your proposal, and the estate is hereby ordered to be distributed as follows.
Yeah. And once that is given, does the executor or the personal representative have any additional liability?
Well, they're not. Once the order for distribution is issued, they're not done with the estate. They still have to make the distributions. Oftentimes, executors want to hold a reserve for any unforeseen or unanticipated expenses. And then what happens is you get receipts from all the beneficiaries or the heirs at law that they've received, in fact, have received those distributions pursuant to the court order. And those receipts get filed with the court. And then when all the assets have been distributed, including any sort of reserve that's being held, then what happens is you file a request for discharge. And the court will review and make sure, okay, the court order said that there was this much in assets and they were to be distributed as follows. These receipts have been filed with the court. Okay, it appears that everything's done. Nothing else remains outstanding and to be done. And then the court discharged the executor. And then
no additional liability. Yep. Hands are clean. Let's go to the next slide. We've got about 15 minutes, Fred.
Okay.
So what are the advantages of probate?
Yeah, just quickly, the court supervision is always a nice thing. If you want a little bit, make sure that the executor's not doing anything funny, not taking too much in fees or not properly.
Attorneys are charging too much, or
yeah, to ensure that well said. So the court looking at the court knows what an estate should cost. The court knows what the process, what's supposed to be done, and they just make sure it's done right. Right.
It's shortened period for claims by creditors. What does that mean?
Yeah, well, recall, we spoke a little bit about you give notice to the creditors and they have a window in which to file a creditor's claim. Well, if they fail to file a creditor's claim, during that window, thereafter they're forever barred. They can't come back against the estate. So you can get rid of some debts simply by the creditor not, providing the proper paperwork to the executor.
And if you were a trustee of a trust, how long does that creditor's claim if you just went about it normally and didn't do anything in addition?
Generally, it's 1 year from date of passing.
So 4 months to 1 year.
Yeah. So if you give notice to the creditor, it's 4 months from the issuance of the letters, the document appointing the personal representative, or 2 months from the date of service of the notice, whichever is shorter.
Yeah. So
Or
even if
if
you have a lot of debt, sometimes the medical bills at the end of life are just enormous. And so, it's really important to see an attorney to see what your estate plan looks like. What do you mean by did not spend a lot of money on trust?
Yeah. So what happens is a trust is a lot more work for the attorney when they're preparing the estate plan. The trust can be, 20, 30 pages long. A will is only going to be 4 or 5 pages. So the cost to do a will is a lot less than the cost to do a trust. So if you just did a will, well, you saved money when you did the estate plan. But if you did the trust, you spent more. But what happens is if you just did a will, then chances are you're going to have to go through probate. So you're going to spend more on the back end with the will, but on the trust, you'll save money on the back end. So it's
a pay me now, pay me later. We'll go through that a little bit later on. Let's go to the next slide. What are the disadvantages?
Especially here in Orange County, the time. Now, the petitions for probate, the initial petition that you file with the court, that'll get set for hearing in 6 to 8 weeks. So that one, because that one has statutory priority for a hearing date. Then once the person's appointed as the personal representative, you have to wait at least 4 months from the date of appointment for the creditors to come in to file claims and whatnot. So at a minimum, you have to keep it open for 4 months.
But usually, I'm going to stop you for a second there, Fred. But most people believe that when you have a living trust, that a person dies, that we can distribute the funds within 2 or 3 months after the person's death.
No, because what happens is when you have a trust, you have to send out what's called a trustee's notification.
So that takes time as well.
That is a 120-day window in which you have to give notice to the beneficiaries as well as the heirs at law, as well as any people that were named in prior documents, that there are these new documents. These are the documents. And if they have a problem with the documents, well, they have 120 days from the date of service of that notice to file a trust contest or some sort of contest.
So a trust normally would take less time, but it does take anywhere from 4 to 9 months normally.
Yeah, especially right now. Well, going back to the will. So after you're appointed and you waited that 4 months, well, now you got to file your petition for distribution. Well, those ones are being set in, right now, if I file it, it's going to get a hearing date in July. Yeah. So, was that 9-10 months out?
Lack of privacy. What does that mean?
What happens is when you have a probate administration, you have to file all this information with the court. You have to explain details to the judge as to, what happened in the course of the administration. You got to identify all these assets. All that stuff goes into a court file in a computer at the courthouse. Well, anybody right now, it's a little questionable whether you can even get into the courthouse. But typically under normal scenario situation, a person can walk into the courthouse, go to the computer in the clerk's office, pull up a person that passed away, pull up their probate administration and can read everything. Oh, this person had this asset and that asset. Oh, wow, that's interesting.
Yeah. Well, it's kind of like when you die, it shows who's the survivor and and when a death occurs, especially for a surviving spouse, they're in a state of shock. My mother was, when my dad died, probably took 2 years to get back to normal. Yeah. And what happens is that is public information. And you're hit with, I can do this for you. I can do that for you. And, what about this? And your name is public, whether or not you go through probate or not, just the filing of the death certificate.
Oh, and I always get letters once I file a petition for probate, and if there's real property in the estate,
yes,
I get tons of letters from people wanting to, be the real estate agent to sell the property, or they're interested in purchasing the property.
Yes,
Yeah, privacy goes up.
Don't ever, as a personal representative, sell to one of those individuals. What about court involvement and supervision? You said that was kind of an advantage. Here you put it as a disadvantage.
Well, again, the judge reviewing everything to make sure it's done right. Okay, that's an advantage, but obviously it comes at a cost. It's you lose the privacy. I mean, you have to file papers with the court. You're playing by the court's rules.
Yes, and the judge is involved. They're the ruler.
Exactly.
So,
they
can rule against you or rule for you. So it's just, sometimes it's an open case. Let's go to the next slide. Cost. This is the major cost, and it has to do with paying the attorney and paying the executor.
Correct. So what happens is under probate administrations, and trusts are not the same way, generally speaking. Probate administrations, the executor of the estate is entitled to what's called a statutory fee. It's a percentage of the value of the total estate. Likewise, the attorney is also entitled to a statutory percentage of the estate. The mathematical calculation I put on the slide, it's 4% of the first 100,000, 3% of the second 100,000, 2% of the next 800,000. So that covers the first million. So if you do the math, if you did a probate administration and you're the executor, okay, at the conclusion of it, and let's say it was valued at $1 million, at the conclusion of it, the court's going to issue an order that your statutory fees, you're entitled to $23,000 as executor. The court's also going to order that $23,000 get paid to the attorney. And the court doesn't really, they don't look into how much work was actually done. They don't care about that. It's just a percentage of the value of the assets.
So if you have $1 million estate going through probate, it'll cost you somewhere between $46,000 and $55,000.
Minimum, yes.
Yeah.
And so now with the trust, you could save money. Granted, there's not the court oversight, so some people are a little take advantage maybe, but but if it's a simple trust administration, you can definitely save quite a bit of money.
Yeah, and this is the statutory fees here are California. Are they different in other states?
Yes.
All trust in the state law, it's all state specific.
Okay.
Yeah.
So that's why you go to a California attorney for
if you move from one state or the other, please go to an estate planning attorney in that state to have them look at your documents, because every state is specific and they control the property and how it gets transferred in each of those states. Let's go to the next slide.
So the trust administration, we go through this one quickly because it's very similar to the administration of probate estate, but the difference is obviously you don't have to file stuff with the court. You can use a court in context of a trust administration, but you're not required to, hence why everyone says a trust avoids probate. But yeah, you got to give notice, you got to marshal the assets, you got to deal with the creditors, you got to file taxes, your accounting and petition for distribution. Same things have to be done in a probate.
Yeah, it's a similar process, and it has to be totally transparent. Accountings are very important, and we'll go through more when we talk about an estate and trust administration, naming an executor and a trustee. We'll spend an hour and a half talking about that. Let's go to the next slide.
So here is just some general information on what you may see out there when speaking with attorneys or trust mills to prepare estate planning documents for you. To do a will, it's obviously much cheaper than a trust because it's not nearly as complicated. And when I'm talking about,
but Fred, I just want to interrupt you for a second. But the free basic documents that an individual absolutely should have is the will, the durable power of attorney, and the advanced healthcare directive.
Precisely. And after that, it's you're getting
trust is optional.
Yeah, you're getting fancier.
Yeah.
So in terms of an estate planning attorney preparing a trust, trust, the will, advanced healthcare directive, power of attorney, generally 1,000 to 30,000. I mean, you go to some of those big firms up in Los Angeles, and you could see a bill, and then a lot of times they'll go into more advanced planning if they're going to charge you that much. Hopefully, some tax saving stuff. But I've definitely seen a lot of people spend way more than they should have. And some attorneys, as scary as it sounds, they try to overplan and they make it more complicated than it needs to be.
Well, the problem there is, Fred, is that the attorney, the more documents that they draft, the more they feel comfortable charging you more.
Well, and on top of that, what always worries me is that is one of their goals to make it as complicated as they can in order to be able to, you know, when the person passes away, you have to go back to that attorney because you can't understand these documents on your own. It's scary when you see that.
If you have your estate planning documents and you cannot understand your documents, that should be a red flag.
Because I always err on the side of simple. I like simple.
Simple
Life's
is
too complicated
just
already.
The best. Generally speaking, most estate plans in Orange County range from 1,500 to 5,000.
If you're doing a trust.
Yeah, with a will, many expenses may need to be paid during the administration process, and that's a legitimate choice. You could say, "Hey, let my heirs pay for the trust for the probate administration. I don't want to pay it during my lifetime."
Yeah, and I just try to make sure that, you know, my clients they're educated on their options, and then the client makes the choice.
Yeah, if trust, you can avoid the court cost. I think this is your last slide, but I'm not 100% sure.
Well, we had a couple of those miscellaneous slides.
Yeah, we got 5 minutes, Fred.
All right, so what happens to estate taxes real quick? If you pass away and the value of your estate exceeds a certain amount, you may have to pay estate taxes to the federal government. Now, in different years, the amount that you can pass without even having to deal with estate taxes has changed. So back in 2017, it was at 5.49 million. So if you passed away in 2017, let's say your estate had $6 million in it. Well, you had to pay taxes on basically 500,000. No, was it 51,000? But yeah, the math part. Come on, we'll deal with that later. In any event, you're going to have to pay taxes on the amount above 5.49 million.
Yeah, but the focus is here on 2020. So the number of people who have estates, 11.58 million, is very small. And if you're married, it doubles.
Correct. So yeah, estate taxes aren't as much an issue these days as they were, 15 years ago.
And there is no inheritance tax in the state of California by the Constitution.
So what happens is an estate tax is charged on, from the estate. Inheritance tax is charged to the person that received the assets, the beneficiary. But again, in California, inheritance taxes are deemed unconstitutional, so they don't.
Let's go to the next slide. This is one of the more important slides. What is a step up in basis? And let me recommend, we got about 3 minutes. Use Apple stock.
Okay, so basis is, generally speaking, the value at which you purchase the stock. When you're calculating capital gains, let's say you turn around, you sell a stock. You sell Apple, and I know there was a split or whatnot. So I'm not exactly certain what it's trading at. But nevertheless, let's say you bought a stock at $10 and then you sold it at $40. Well, per share, you got a $30 gain. So the basis is the $10, the value you purchased it at. And you're going to pay taxes on that gain. Now, what happens is when you gift an asset to someone, like let's say you give your house to your child during your life. Well, they take your basis. Now, the concept when it comes into estate planning purposes, there's something called a step up in basis. And in the event that you pass away, most assets will receive what's called a step up in basis. And that is changing the hopefully lower figure in terms of calculating the capital gains. So let's say that same stock, you had it at $10 and then you died, it was worth $28. And then through your will, your son got it at, and he received it. Now it's $30 when he actually got it. He sells it at $30. His basis is the value of that stock on your date of passing. So he's only going to pay capital gains based on the $2 gain, the 28 to 30 figure. So it's just important.
But the bottom line the bottom line is that if you're going to gift an asset during your lifetime, you want to make sure that you understand the basis of that asset.
Correct. There's just a lot of tax ramifications to it. You want
lots of tax ramifications. The step up in basis is one of the biggest benefits from a tax point of view from for dying. You know, your heirs receive a step up in basis. So normally income taxes are not an issue, except if you own an annuity. Annuities don't get a step up in basis. Neither does your IRA account.
I was going to say.
Yeah. So there are some things out there that don't. And gifting, people believe that you can only give a 16,000. Is it 16,000 this year?
It's somewhere right around there.
Yeah. Remember, you can give over that amount, but that just means that you have to file a gift tax return. Okay. And we'll talk more about that in the living trust section. Don, do we have any questions that we can get to in the next couple of minutes?
Fred, why don't you, unless you want to talk about that, why don't you stop sharing? Since Pete seemed to just stop that one. We don't need the final steps. We've covered them, I think. There you go. Most of the questions that we've had, I've answered some of them, but because this is a basic section and we have individual sessions coming up on them, I've deferred those off. So most of them, I think we can really leave until later. And either I've said that to people or we have a record of all of these because the question and answers are all saved. And so we review them. We have our list of what was said last week's session and make sure that we cover those subjects as we go along. So we'll make sure that gets done, but that's where we are.
So the next session next week, Wednesday, we're going to go into detail on the durable power of attorney for finances, and we're going to go through in detail the advanced healthcare directive.
So as a part of planning for incapacitation?
Correct.
Thank you. Okay. So I thank you, Fred. Thank you, Pete. Thank you to the group. As I say, we will track the questions and make sure that we cover these subjects as we go along. And I thank you all very much for being here. And I've enjoyed it, watching this whole process going on and listening, as it were, to the question and answers coming through. So again, thank you, Fred. Thank you, Pete.
My pleasure.
Yeah. Thank you, Fred. Thank you, Don. Really appreciate it.
We will see you next week. Thank you.
Bye-bye.
Stay safe and healthy. Thank you.